All right, let's get started. Hello. So welcome to MCA's donors who are joining us today for this webinar. Really excited to talk to you and give you an inside peek into what's going on with the PolyMet trial this week. And I do want to give a special thanks to our sustaining donors, those of you who choose to give month after month. Makes a big difference in our work. We've been working on PolyMet for years. We expect this will continue well into the future, and being able to count on you in that way is really helpful. So thank you. I'm Catherine Hoffman. I'm the CEO of the Minnesota Center for Environmental Advocacy. And with me here today is Kevin Ruther, our Chief Legal Officer.
Hello, everyone.
All right, so we are going to chat a little bit about what's going on in PolyMet and in the trial specifically this week, so that you all know, and then we'll take a few minutes at the end to answer a few of your questions. So feel free to put some questions into the chat, or excuse me, the Q&A feature as we go along, if there's things you want us to talk about. So Kevin, why don't you set the context for us here? What has happened broadly on PolyMet up until this point in 2020?
A lot.
Fair enough.
So I was just telling you yesterday, Catherine, I came to MCA in 2005, 15 years ago now. And I remember one of the very first files that I looked at was PolyMet. I think it was back in 2004 that they initially put in an application and started their environmental review. So MCA has been working on this project for a really long time. It's gone through a couple of different iterations of environmental review. People will remember that back in, I think it was 2010, they had to kind of go back to the drawing board because their environmental review was inadequate. And now everything has kind of come to a head in 2018 when the state decided to issue permits for this project. And there are a number of different permits, right? So with a project this size, they have to get approvals from both the federal government and the state government. And those approvals are subject to legal challenge. And so that's kind of where we're at now. We have, I think at one point we were up to about 8 lawsuits that were pending, challenging various aspects of this project and the governmental approvals.
Okay. All right. And so which permits has MCA challenged?
So again, there are both federal and state. On the federal level, we've challenged what was referred to as the land exchange. So PolyMet didn't have access to its minerals. It didn't have the rights to the surface to dig the pit that it needs to dig to get at the minerals. And it had to exchange land with the Forest Service in order to get those rights. We alleged in federal court that violated the law. That case actually has been dismissed, but it was dismissed without prejudice. So there's still sort of a potentially live case there. We've also filed a federal lawsuit that challenges the wetlands permit. So they will be destroying thousands of acres of wetlands, the largest wetland destruction in the history of the state, actually. And so we're challenging federally that permit as well. And then at the state level, the main permits are the DNR permits, the permit to mine and the dam safety permit. And then the MPCA, the Minnesota Pollution Control Agency, has also issued a couple of permits, one under the Clean Water Act, the other under the Clean Air Act. Both of those have been challenged also.
Okay. So we're here today really to focus in on this water permit that was issued by the Minnesota Pollution Control Agency. Now, usually when MCA or somebody challenges a permit like this, they go to the Minnesota Court of Appeals, right?
Yeah.
But the hearing this week is in district court, which is more like a trial court. So how did we get here?
Yeah, that's a really good question. So it's true that most of our cases, MCA's cases, end up being at the Minnesota Court of Appeals. And the reason for that is that we tend to be challenging agency action. So the government is giving some approval to a project, in this case PolyMet. That approval is issued under the Clean Water Act. In order to discharge, well, what the Clean Water Act does, I guess I should start there, is it prohibits the discharge of any pollutants into a water of the United States. So PolyMet is saying to the government, we are planning to discharge pollutants. Without a permit, they can't do that, right? And so the permit is what they need in order to operate and essentially to pollute Minnesota's waters. I mean, that's kind of the basis of permitting. We are allowing them to put some pollution into our waters. That agency decision is built on a number of different pieces of evidence and scientific studies and what's referred to in administrative law as the record of the agency. And so when we want to challenge an agency decision, we're bound by that record. All of the documents, the studies, the evidence that the agency has relied on in making that approval. And under the law in Minnesota, appeals of these agency decisions based on the record go to the Minnesota Court of Appeals.
So there's a problem with the record in this case.
There is a problem with the record in this case, and that is why we're in the district court. So there's a provision in our law that says that the Court of Appeals, if there is quote unquote irregular procedures or procedural irregularities, and sorry, I got that reversed, the Court of Appeals can send the case down to the district court, and the district court can have an evidentiary hearing on what those alleged procedural irregularities are. And that's where we are today.
All right, so we're in district court over the record. What are we trying to prove here? I mean, what is the problem with the record that MCA is trying to highlight in these court hearings?
Yeah. So for me to explain that, I have to back up one step. Under the Clean Water Act, the federal EPA has a role to play. Okay. So I described that there's this permit that PolyMet needs in order to discharge its pollutants. That permit is required by federal law, the Clean Water Act. The way that the act is designed, however, it gives a role to all of the states to play in permitting. And so what we've got is the Minnesota Pollution Control Agency as the permitting agency working, with PolyMet to develop this permit. But EPA is still kind of the backstop. I think of them kind of as the big brother, right? And we are in Region 5 of EPA. Their headquarters is in Chicago. So that Chicago office has oversight over Minnesota's permitting. And EPA staff, I mean, there's a full staff in Chicago that work only on Clean Water Act permits. And this is a huge project. They've been involved in, these 15 years of reviewing and the environmental review, all this stuff. And so they're very interested in making sure that Minnesota issues a good protective permit to PolyMet, because as you know, there's potential for really bad water pollution to result from this project. In this case, what we are alleging is that the Minnesota agency, the Pollution Control Agency, basically worked to suppress the comments and the criticisms of EPA in this record. Now, in a typical case like this, where EPA is involved, they would submit written comments into the record so that the public and everybody, we as MCEA and our experts who are commenting on this permit would know what their criticisms and concerns are. I've been doing this for 15 years. Anytime EPA is involved in reviewing a permit, they've always issued written comments, and those have been part of the administrative record. In this case, EPA's comments were missing. And that was sort of a red flag for us. And so that led to the filing of this motion with the Court of Appeals saying something is off here, right? And then some documents were leaked out of Chicago, and it became apparent that actually the PCA and the political appointees at EPA had made this agreement to essentially keep the written comments out of the public record. That's what we've alleged.
Okay. All right. So this is pretty unusual. We're in district court. And I think the media recognizes that too. There's been a ton of media coverage. Our communications staff has been really busy with stories that have been published all over the country. So these reporters that are in the room, what are they seeing? Like what kind of quotes or information or testimony has been offered that actually helps prove this case?
Okay. So the case, just to back up again, started on Tuesday. So we're in our third day. And the first day, a lot of it was, the judge making decisions about what the rules of the case were going to be, what is the scope of the case going to be. Actually, you brought up the media. One of the things that he had to decide, which was really interesting, was whether or not he was going to allow the media to do videotaping and recording and take pictures in the courtroom. There's a provision in the Minnesota court rules that does allow that, but the media outlets have to give a notice, and that notice can be objected to. In this case, actually, PolyMet objected to the Star Tribune and Minnesota Public Radio and other media outlets having their cameras and their recorders in the courtroom. So one of the first things that the judge did was to say, no, this is going to be a transparent hearing, and he did allow the media outlets in. And so you're right, the courtroom is packed, particularly on that first day with a lot of folks from the media. So anyway, on that first day, he was setting the rules of what kind of evidence he was going to admit and whatnot. Mm-hmm. And then we got to call our first witness, who was Kevin Perard. And Kevin Perard is a longtime EPA employee. He worked in that Chicago office that I was describing for over 30 years. And 9 of those years, he was chief of the Clean Water Act permit section. So kind of, top guy of all these staff people and experts who review permits. And he was able to explain that what happened in this case was really extraordinary. He said, I wrote down a couple of the quotes from him in my notes, but one of the things I recall him saying was that over those 9 years, he and his staff had put in comments and reviewed over 700 permits. And this is the only one where there was this kind of agreement where they wouldn't put the comments in writing. He said in nearly every one of those 700 permits, there was an email or a comment letter that described the EPA's review, and if they had concerns, described in detail what those concerns were, laid out the regulatory basis for the concern, so that both the agency, the MPCA, but also the public and other people who would be interested in EPA's stance would know.
All right, so it sounds like PolyMet sort of got special treatment here. For some reason, this permit was treated differently than hundreds of other permits in terms of EPA comments. It
did, and that came out this morning too. So after Kevin Perard was done testifying, the second witness was the former commissioner of the Minnesota Pollution Control Agency, John Stein. And John said this morning, when asked, about this procedure that was used for PolyMet, I know that I have this here. He was asked about this approach, and he said, I know it was an approach that was specific to this permit, meaning this was a different approach, a unique approach that they had not taken with any other permits. So yeah, this was special to PolyMet, and I think that goes to our main allegation that there are procedural irregularities here, like something was not the same as what the agency would historically do.
Okay. So in addition to a lot of media being in the courtroom, it sounds like there are a lot of lawyers involved.
There are very many lawyers.
PolyMet and DNR have some big law firms representing them. So what does it take for a small nonprofit like MCA to mount a legal challenge like this?
Well, this has been a lot of work, right? It's been a lot of work over many years. But this case in particular, this case on, excuse me, the water permit, and the fact that we're having this hearing in district court is extremely resource intensive. We've had one of our lawyers, Elise Larson, working on this case full-time for months now. She's been working weekends, evenings. As you know, many of us were here over the weekend preparing some of the exhibits. There are 836 exhibits that we have prepared for this hearing alone.
And by exhibit, we mean pieces of paper, evidence that we want the court to look at.
Yes, emails, all different kinds of documents that we're going to use and have witnesses describe and then get admitted to evidence so that the court has a better record when it goes back up to the Court of Appeals. So yeah, it's been very resource intensive. And I will say that you're saying that the courtroom is filled with lawyers. It's really filled with lawyers from our opponents.
Yeah.
PolyMet is totally lawyered up, as is the state. And so you've got PCA's own lawyers there. You've got the lawyers that they've hired from Holland and Hart and another law firm. So we're up against some big guns, but I think we're doing a great job of it. We're also benefiting from some pro bono help from the Mazin law firm, which has been really, really great, really helpful.
As well as our partners at Fond du Lac.
Yes.
Yeah, great. So despite the fact that we're, the underdog, that we're outgunned here and in lots of places where we fight, MCA has been getting some good wins at the Court of Appeals recently. And not just on mining. Do you want to say a little bit about that?
We have. Well, I should start though with a mining win.
Yeah.
Which is we won the appeal of the DNR permits, which is it's huge. I mean, the case isn't over yet. PolyMet has already announced that they're going to seek review in the Minnesota Supreme Court. We will oppose that, and depending on what the Supreme Court does, if they want to review the case or not, we'll be there arguing. But that was a really big deal. So those are the permit to mine and the dam safety permit. And what the Court of Appeals said there is that we were entitled to a contested case hearing, which is an administrative trial. Assuming that we do go to that contested case hearing, that also is going to be an enormous lift for us, because that, again, it's like an evidentiary hearing where we're going to have tons of documents, tons of witnesses, lots of experts. That'll be a lot of lawyering on our part, but it's
and on PolyMet's, I'm sure.
And on PolyMet's, but it's an amazing accomplishment. I think that we were successful at the Court of Appeals on those permits.
Yeah, but we had kind of what we referred to as a hat trick too, right?
We did.
So there were a couple. There were two more.
So in
wins.
the last couple of months, in addition to that DNR permit reversal, we won a case that came out of our climate energy program. That was Minnesota Power's proposed natural, actually fracked gas plant in Superior, Wisconsin. So the Court of Appeals agreed with us that before that plant should be built, it needs to go through environmental review, and it reversed the permit and the decision of the Public Utilities Commission approving that plant, sent it back. That also may be going to the Minnesota Supreme Court. We'll see. So that one's not over yet. And then we had a big win that involved a factory farm. This was a case down in Winona County where it was a huge expansion of a dairy from, I think, about 1,000 to 6,000 animal units. And we challenged that permit. It was also a Minnesota Pollution Control Agency permit, alleging that it wasn't going to be protective of water quality, and also that they had failed to look at the greenhouse gas impacts from this dairy expansion. One thing that people don't realize is that ag is actually right now the largest sector of greenhouse gas emissions in Minnesota. And so it's something that we're really trying to focus on and get people to think about. We need to start mitigating those emissions. The Court of Appeals agreed with us that in environmental review for this kind of a project, you do have to look at greenhouse gas emissions. And so they reversed that permit and sent it back to the agency.
Great.
Again, we don't know if that'll be, if the agency is going to seek review in the Supreme Court, but lots of wins just in the last few months.
That's
so
great.
That's great.
Good. All right, well, now we'd love to take a few questions from some of our participants. So one question I've seen popping up is, this hearing in district court that's going on this week, is it something that we can win? So in other words, like, what's a good outcome? What if we get what we want?
Yeah, so the district court is not charged with, reversing the Clean Water Act permit that was granted to PolyMet. So we can't win in the same way that we won on the DNR permits from this district court action. What the district court is really asked to do is to see whether or not there needs to be more information in the record due to the procedural irregularities. And so a win here is for the court to agree with us to say, yeah, this is unusual. The agreement that they made to suppress these comments was irregular, that the comments should not have been excluded from the record, and so they need to be added into the record. We have some other allegations as well that I didn't describe, like that the Pollution Control Agency, for example, was destroying its own documents, notes from meetings, emails, things that they failed to produce and didn't put into the record that we now know exist. And so a win is for the district court to say, to agree, yeah, they shouldn't have been destroying their emails, they shouldn't have been wiping their hard drives. All of that information, to the degree that it exists still and we can find it, needs to be added to the record. So that then when we go up to the Court of Appeals again, we have a fuller record and a better record on which to make our legal arguments.
Okay. All right. Another question that we received is, how are we cooperating with other groups? So what level of cooperation is there, and does that make us more effective when we work together?
Absolutely. We are really kind of co-counseling with a number of different groups. And so in our coalition, as Catherine mentioned, is the Fond du Lac Band of Lake Superior, Chippewa. We are also collaborating with Water Legacy. And then we are representing Friends of the Boundary Waters Wilderness and the Center for Biological Diversity, in addition to ourselves, Minnesota Center for Environmental Advocacy. I mentioned the Maslin Law Firm that is providing some pro bono help to us. We also have lawyers from the Nyland Law Firm who are helping out. And yeah, I mean, we have definitely relied on each other, all of those groups working together to pull this off.
Yeah, my observation is that legal teams spent a lot of time together leading up to this trial to come up with a plan on how to handle each witness and how to get all this evidence into the record.
Yes.
And that it was really a great team.
Yeah.
Yeah. Another question that we received is, what is the timeline for the Minnesota Supreme Court to hear any potential appeal of the recent decision? I assume we're talking about the permit to mine decision. Right, so DNR, so this is the one you're talking about where the Court of Appeals reversed DNR's approval of the permit to mine.
Okay, so the timeline for the agency and PolyMet to request review is 30 days from the date of the decision. It's the decision on January 13th, maybe? I can't remember.
Correct, the 13th.
A few weeks ago.
I remember it was the day of our board meeting. That's why I know.
Okay. So, I mean, PolyMet has already announced that they're going to seek review. That will become official 30 days from the date of the decision. And then the Supreme Court, different from the Court of Appeals, they don't take all of the cases that people would like to have them review. So their review is discretionary. there's not really any way of knowing whether or not they will grant review. And there's not a timeline for them to make a decision on whether or not they're going to grant review. But typically we would hear maybe in 2 to 3 to 4 months whether or not they'll grant review.
Yeah.
And from that date, then they will set a schedule. And that case would be briefed. PolyMet and the agency would file their brief. We would have a responsive brief, and they'd have a reply brief, and then there would be a date for an oral argument.
And realistically, from the time from now until a decision from the Minnesota Supreme Court, if they were to take that case, I mean, it could be, what, a year?
Yeah, it's unlikely to happen until next year.
Yeah, okay.
Probably next fall.
All right. Another question that we received is about the issue that you mentioned about the hard drives being wiped and PCA destroying emails. And how does that factoring into the hearing right now?
It's actually right now, as we're sitting here speaking, if they're not on lunch break, they may be talking about this issue.
Yeah.
I was in the courtroom this morning, and the former commissioner, Linkstein, was being asked specifically about document retention, what the policies are of the agency. And yeah, so it's definitely one of the issues that is getting a lot of attention.
And the judge has not decided how he wants to handle that yet. Is that correct?
Correct. We had brought a motion. So this is referred to in legalese as spoliation, sort of the destruction of evidence when you should be keeping it. And we brought a motion relative to that, but the judge deferred any ruling on it.
And what the judge could do with that is make some assumptions, right, about what that evidence might have said if we had it.
Yeah, so he could make an inference that if the information was destroyed or some document was destroyed, he could infer that it was beneficial to our case because it shouldn't have been destroyed.
Okay. All right. So what kind of work can PolyMet do on the ground while these cases are pending? Is PolyMet able to start building their mine?
No.
Well, that's good.
Yeah. So, yeah, and actually, even before we got the good DNR decision from the Court of Appeals, they had issued a stay on those permits. So without the permits, PolyMet really can't take any actions pursuant to the permits.
Well, and we've also heard a little bit from PolyMet through the press that this is starting to create some challenges for them in raising the capital that they need to move forward with this project. That's something they're trying. They could do that. They could go raise money from investors in theory, but with the permits now reversed, that's going to be harder for them realistically.
Yeah, I mean, they've been waiting for those permits specifically for the ability to go out and raise money based on having the permits. Now that the permits have been reversed, that's going to be more difficult.
Yeah, yeah. So one person asked, how can we stay informed of this when the case is in session daily? There isn't like a live stream of the proceedings. My recommendation would be our Twitter account.
Yes,
definitely. Does that seem like the best thing?
Yeah, Aaron and Adam are over there. They're tweeting. And we're basically just tweeting the facts, not trying to give a lot of opinion. So I think that would be a good resource. I think that also our website,
Yes.
People versus PolyMet, we have this page up, and I think there will be information added to that as we go through the hearings as well.
Yeah. And the media outlets that seem to be doing regular daily coverage so far are the Star Tribune, MinPost, and NPR. Dan Crocker from NPR is there.
Yeah.
So it's like following those media outlets.
Yeah.
Is helpful. We have one more question. It looks like it's from a lawyer. Did the MPCA and its lawyers represent in court filings that the PCA didn't know of efforts to keep EPA comments out of the record? And if so, And if PCA, it turns out the PCA was not being honest about that, what consequences might there be for the agency?
So, I mean, it was known, obviously, to MPCA and to their lawyers that EPA comments were not submitted to the record. There's an issue here about, what was the intent of the agency? And my position would be that the intent in some ways doesn't really matter. If the procedure was irregular and documents were left out of the record, then those documents need to be discovered and added to the record. And so, I mean, I think there are competing versions of the story, and PCA's lawyers are working hard at telling a story that there was no intent to do anything wrong. Their story is that, this was about efficiency. They started making that story today in their direct examination of Commissioner Stein. And we'll see how the judge feels about that. Whether it was about efficiency or whether they actually intended to scrub the record for other reasons, in some ways is irrelevant. The fact is that this procedure was irregular and those comments were excluded, and they need to be added to the record that's going up to the Court of Appeals.
Yeah. Well, and it was irregular in a way that was less transparent to the public.
Exactly.
So that's a problem. Yeah. And that's one of our other questions is how can we as a state regulate sulfide mining if this process is not transparent?
Yeah, well, it's really good that this is all coming to light, because I think the agency is learning one thing through this, is that they would not do this the same way again, right? And we will be there to make sure that they don't. I mean, we've also learned a lot through this.
Yeah.
And to not necessarily take for granted that when we send in a Data Practices Act and get nothing back, that there's nothing there, right?
Right. We know now a lot more about the agency's practices in terms of keeping or not keeping documents.
Exactly.
It's a big deal.
I mean, I submitted a Data Practices Act request specifically for emails about this issue in, was it June, or I think it was in June of this past year, and received nothing in response. And now it's come out through EPA on the other end that there were emails specifically responsive to what I had requested that we didn't get. And so that's very concerning.
Yeah. Well, and I think there's a bigger question here too, not just from this district court hearing, but from our other cases about some of the deficiencies of Minnesota's laws and rules protecting us from the pollution of sulfide mining. I mean, we're finding there's a lot of areas where that regulation is not that great.
Right.
The agencies have a lot of discretion to bend them or to ignore them altogether. And this idea that, Minnesota has the best laws in the world and therefore we should be mining here is not particularly accurate.
Right.
Yeah. So I think that's another big question that's a takeaway from this experience with PolyMet is we as a state are really not ready for this industry. We don't have the laws in place.
Yes.
Yeah. So there's a question about politicians and are they going to take a stand on PolyMet or twin metals? I mean, I don't think that, not this week. I mean, I don't know that we have new information on that at this point.
Well, I mean, with regard to PolyMet, I think the stand has been taken, right? It is now the Walls MPCA that's defending this decision. And from what I understand, I think that Tina Smith has been supportive of the permit as well.
Yeah.
Twin metals, we don't know yet, right?
Yeah. Well, I think it raises a good question too about what are these these cases on PolyMet and these decisions that we're getting, what do those have to do with other mines, if anything?
Well, they have a lot to do with other mines, I mean, in a lot of different ways. One, you know, if I reflect on just what we have learned over the last 15 years, I think that we're going to be so much more effective in ensuring that these other proposals are really thoroughly scrutinized and that we build really good cases to prevent them from harming Minnesota's environment. They also set important legal precedents, you know, and kind of establish, for example, the fact that the Court of Appeals reversed the DNR permits and said to the DNR, no, you need to have a contested case on all these disputed issues. That sets a precedent for the next time, whether it's Twin Metals or some other mine proposal. When it gets to that point where there are disputed issues, we should be entitled to a contested case.
Right, which means the mining companies don't just have to show that they can meet permit conditions to DNR or PCA, they have to show it to an independent administrative law judge. Right, which is a really big change in how they would approach this process. All right. Well, we're really grateful for all of our donors who joined us here today, and we hope that you learned something and know more about MCA's work around PolyMet, and thanks again. We'll be in touch.